So the Supreme Court came out with a very big judgment in constitutional law, just as many students all over the country, not just Open University law students, would be starting a course in constitutional law. So I guess that's exciting, but also possibly terrifying for students.
Yeah, it seems to have kicked off a certain amount of, we could call it excitement, but also trepidation about what it means for the studies of constitutional law, as I understand them. And whether this changes everything about constitution, constitutional law, or what they really need to know about it for the upcoming year.
From that point of view, it's better that it's happened at the beginning of the course rather than just the week before the exam. But it's a good illustration of a general principle about studying law, that part of the challenge is to see how some new development fits in often centuries of tradition, and not to be intimidated by that, but to look forward to it and to understand why the law may be evolving.
Absolutely, and also the new developments in law happen. Laws are passed that might change fundamental aspects of criminal law or other areas of law during the course, and it's something you just sort of have to get to grips with. But in public law, it's been a bit more unusual for things to come out that are so newsworthy and seem to have a potentially radical impact on the kind of study of the subject. It's a bit more slow-moving, sort of evolving field usually, but it's a bit more exciting at the moment.
Yes, so to reassure students, it's always going to be the case that if the Supreme Court's looking at an issue, there must be a way of arguing it on either side. Otherwise it just wouldn't be there by definition. So some set of lawyers are being paid a lot of money to argue the best possible case against the government and for the government. So a student ought to be able to pick up how to structure an argument for either side. And then often, not in this case, but often the judges give different judgments. But even in this case where there's one judgment, which perhaps we can talk about on another occasion, even then we know that senior judges hearing it at first instance disagreed with the Supreme Court, and in Scotland and in England and Wales, judges disagreed with one another. So disagreement is not something to be feared.
No, that's right. There were quite senior judges in both England and Scotland who heard the case and came up with very different outcomes based on very different reasoning. And so, it's possible to reasonably disagree about these things. And as you say, the Supreme Court judgment was unanimous, which is something that was quite interesting about it. But again, there were arguments put forward by both parties, and law and the development of law, especially in the courts, is often all about that sort of dialectic, that sort of arguing out the case in the context of the law.
Yes. I guess a new student might also think, does it matter what I believe about Brexit, and are the Supreme Court judges somehow infiltrating their views about Brexit, the substantive issue, into their judgments? And from my own point of view as an examiner as well as a teacher, we're never in law going to be judging people according to whether they agree with us on the underlying merits. No,
absolutely not. It's about making a good, reasoned legal argument in your sort of depending on what your assessment is, but for the examiner, rather than which view you have on Brexit either way, and then therefore it's also kind of sensible not to just because the political views on Brexit may not be germane to the legal issue you're arguing. You don't necessarily have to talk about the political views on Brexit to answer the legal question.
So I wonder if we could help students by perhaps giving a little bit of background about our own interests. Your own research looks primarily at a particular period of history. Maybe we come to that in a second, but I thought if I could just say, when I was a student, which is such a long time ago, it was 1976 to 79, and I studied European, as it was then called, European Community Law. So the European Communities Act was in 1972. We joined on the 1st of January 1973. There was a referendum in 1975. I voted to stay in the European community, as was in 1975. I just turned 18, so it was the first time I got to vote. I took my A-levels. In 1976 I went to university. I was studying European community law in 1979, I took my final exams in European law. But along the way, one of the issues we discussed was, what if we ever wanted to withdraw from the European community, as they then said? And students thought, this is a ridiculous question. I mean, why are we talking about that? Why don't we look at the real issues? And there were talks about butter mountains and all these kinds of issues as to, was the European Union agricultural policy distorting the market? And that's what students at the time wanted to talk about. Now, 40 years on, it seems like quite a good idea that the tutors asked us to think about big issues. And so even if the question doesn't come up in the exam, that's not all that a law degree is about. And it's very important both to look at the current issues and to study the history. I don't know if you want to say anything, Simon, about your research looking at a dark period in the law in Europe, and how today we're still interested in that and trying to learn from it.
Well, first I'd say just talking about, asking students the big questions. A few years ago when I started tutoring public law, before the EU referendum question was really sort of, some people wanted to leave the European Union, but it was much less high profile. We talking about parliamentary sovereignty and legal and political sovereignty of Parliament, and the European Union withdrawal was always something that legally Parliament would have the power to do, but politically is a very challenging thing to do, and it looks as maybe borne out by the current circumstances. So you sort of raise that as an interesting distinction between what the Parliament can do with its sovereignty, but what it might find difficult to do. And obviously the referendum is another level of popular sovereignty that kind of perhaps enables potentially that to take place. But even in a short number of years, the way we look at that question has changed so much, which is quite interesting. Things can change quite quickly. As you said, my own research, is primarily into sort of the public law of Nazi Germany, and an increasing awareness of the role of law in the Third Reich in sort of moving towards the sort of catastrophic outcomes of that regime, and also, as you said, an ongoing interest in that today. And I mean, it's never really gone away as a subject of historical interest, but a revival in terms of interest in it, and whether we can draw any parallels with new waves of populism and right-wing populism in particular across Europe and elsewhere, and constitutional moves in some countries. Question of whether are we moving towards something anywhere close to fascist rule, or is that term totally inappropriate? Is it something very different now?
Yeah.
And those sort of parallels and questions are very, very interesting at the moment.
And when I was studying both constitutional law and then jurisprudence, the philosophy of law, and these subjects have an overlap, we would look at those issues of, obviously it was a lot closer to the war then, but we looked at those issues of, well, were everyday legal transactions in Nazi Germany, were they law or not? Before you get to the big dilemmas of whether to obey an unjust law and what force it had. But one of the reasons we were looking at that was because in the 1960s there were cases, for instance, when what was then Rhodesia made a unilateral declaration of independence, breaking away from the constitution bequeathed by the United Kingdom. And again, the same issues would crop up, that whether or not you agreed with the new regime, was it effective? Did that take over the legal system? And so through every generation, every decade, somewhere in the world, there'll be these kinds of questions about what is law. And at the fundamental levels of a constitution, it can be difficult to know. It could have been difficult for the Prime Minister's legal advisors to say what would happen until we actually got the Supreme Court judgment.
I think that's right. Returning to the judgment, that that the prorogation power and whether it is justiciable in the courts and to what extent and how is a very open-ended question for the legal advice to the government to try to deal with, and the lower courts that came before the Supreme Court. So it's very much a question of where the law sits, especially, well, it happens in countries with a written constitution as well, but especially you don't have a codified constitution, and there are sort of potential gaps or flexibilities in the constitution that need to be established and filled out sort of as you go along, as cases arise in the common law system.
Well, in another conversation, we'll look at the judgment. But just to conclude on this, then, I'm struck by how events in the wider world mirror the hypothetical questions I was asked as a student. Not only in this case, but for instance, Extinction Rebellion tactics of protest, gluing themselves to the ground or to a building or to a lorry. It's the kind of question we were always asked in constitutional law problems. If there's a demonstration and people are doing this, do the police have powers to do that? And similarly then, I think the conclusion of this conversation is that if students have been asked, say, last year, should a Prime Minister try to prorogue Parliament for 5 weeks just before a Brexit deadline, would the courts intervene? You could have answered it in different ways. You could have answered it like the Attorney General seems to have done and said, no, it's not justiciable. Or you could have been more adventurous and said, I think the courts would intervene if you made that kind of bold decision as a Prime Minister. That would be subject to challenge. But either way, we the examiners would be looking at your arguments, not necessarily whether we agree with you on the outcome.
Yes.
Thank you very much, Simon.
Thank you.